According to the CEO of Ripple, the Securities and Exchange Commission has lost sight of its job to protect investors. At an event called Ripple Swell that took place in Dubai, the CEO of Ripple, Brad Garlinghouse, stated to Dan Murphy of CNBC that he believes the Securities and Exchange Commission has lost sight of their job to protect investors. Ripple was awarded a significant victory in July when a judge decided that XRP was not a security in and of itself. The next significant phase in the lawsuit is a discovery process for remedies, which is the next important step. It is Garlinghouse's goal that the United States will surpass the current state of affairs in which the regulation of cryptocurrencies is determined by litigation and arrive at a stage when Congress will create federal rules that control digital currencies. The chief executive officer of the blockchain business Ripple has some harsh words to say to the Securities and Exchange Commission of the United States. At the Ripple Swell conference held by the business in Dubai, Brad Garlinghouse expressed his belief to Dan Murphy of CNBC that the agency has failed to recognize one of the most important responsibilities that it has as a regulator. I believe that the Securities and Exchange Commission has, in my judgment, lost sight of its job to protect investors. The issue that needs to be asked is, who are they doing this journey to protect? As said by Garlinghouse on Thursday, the Securities and Exchange Commission did not immediately respond to CNBC's request for a comment. The Securities and Exchange Commission accused Ripple and its officials of committing a securities fraud that was worth $1.03 billion by selling XRP to retail investors in the year 2020. As a result of Ripple's failure to register an ongoing offer and sale of billions of XRP tokens to investors, the regulator asserted that investors were not provided with sufficient disclosures regarding XRP and Ripple's operations. A significant victory was bestowed upon Ripple in the month of July when a judge determined that XRP does not constitute a security in and of itself. After this, the Securities and Exchange Commission's request for an interlocutory appeal was turned down. After that, in October, the Securities and Exchange Commission dismissed the accusations of securities law violation that had been brought against Garlinghouse and Ripple CEO Chris Larsen. The process of discovering potential remedies is the next significant step in the case. In accordance with a proposed schedule that was presented by the SEC, SEC has 90 days beginning on November 9 to carry out discovery that is connected to remedy. Not only is it a step in the right direction for Ripple and Chris and Brad, but I believe it is a move in the right direction for the entire industry that the Securities and Exchange Commission has been brought under control in the United States. And I'm hopeful that this will be a thawing of the permafrost in the United States for really seeing an amazing industry that has enormous potential thrive in the largest economy in the world, Garlinghouse said in an interview with CNBC. Garlinghouse has high hopes that the United States will one day go beyond the current state of affairs in which the regulation of cryptocurrencies is determined by an ongoing stream of litigation and arrive at a moment where Congress will enact federal rules that control digital currencies. One of the things that people talk about is one of the definitions of insanity is doing the same thing over and over again and hoping you'll get a different outcome. The Securities and Exchange Commission is doing the same thing again and over again. In addition, they believe that at some point in the future, they are going to be presented with a different outcome, Garlinghouse concluded. Grayscale also had, in my opinion, a significant victory in the United States regarding the Bitcoin exchange traded fund, where the judge had to get a federal judge talking about a federal agency. The CC saying that the SEC is being arbitrary and capricious, he added, referring to a ruling from an appeals court that stated that the SEC was incorrect to reject an application from Grayscale to create a Bitcoin exchange traded fund. In general, judges have a tendency to be rather moderate and make an effort to avoid being overly dramatic. These are words that are condemning. Therefore, I believe that at some point in time, the Securities and Exchange Commission will need to take a step back and acknowledge that their strategy of regulation by enforcement, which consists of simply bringing cases, is in need of a change. According to a law professor, the Ripple ruling could act as a guide for emerging cryptocurrency companies. Despite the fact that the finding in the SEC versus Ripple litigation was released 5 months ago, the summary judgment decision has been causing prominent legal experts to express their thoughts. Judge Analisa Torres, who is the judge who ultimately decided the case, is said to have carefully highlighted the significance of facts and circumstances in cryptocurrency sales in accordance with the securities law that is currently in place, as stated by the legal expert. According to him, the ruling not only acknowledged the one-of-a-kind nature of trading digital assets, but also successfully applied the securities law that was already in place, particularly the Howey case, a legal criteria that determines the transaction that forms a security was created in the Howey case in 1946. This was done for the purpose of clarity. An attempt by the SEC to circumvent Howey was unsuccessful. According to Verrett, the Securities and Exchange Commission made an effort to circumvent the use of the Howey test in the Ripple case by establishing an alternate reality. However, the SEC did not provide any legal precedent to support its position. In a noteworthy move, the Securities and Exchange Commission asserted that XRP is by definition a digital asset security. Furthermore, the commission argued that all sales of XRP satisfy the multiple prongs of Howey, which means that these transactions constitute investment contracts between Ripple and the buyer and seller. It was confirmed by Judge Torres that facts and circumstances are relevant in specific offers and sales in Howey's analysis, regardless of the asset's underlying technology. This is in contrast to the assertion that was made by the Securities and Exchange Commission. In the beginning, the Securities and Exchange Commission asserted that Ripple's institutional XRP sales, programmatic XRP sales on digital exchanges and other distributions are all considered to be investment contracts. In spite of the fact that the judge found that Ripple had broken the law by selling XRP to institutional investors, she decided that programmatic sales are carried out on digital exchanges through the use of blind bid or ask transactions between unknown parties. The court supported her verdict by referencing 3,000 affidavits that were filed by members of the XRP community. These individuals claim that they were unaware of Ripple's existence when they purchased the token on digital exchanges. As a result, she came to the conclusion that programmatic sales of XRP do not constitute securities, contrary to what the SEC asserts. A non-existent fact cannot be invented by the SEC. Bart stated that the Ripple verdict explains that the brush is not too wide to allow the regulator to make up non-existent facts and situations in order to validate its arguments. This is in contrast to the assertions made by Gary Gensler, who is the chair of the Securities and Exchange Commission, that Congress provided the commission with a broad brush to apply the Howey test. He claimed that the ruling on Ripple might serve as a template for rules that adapt to the unique needs of crypto asset owners. Is similar to how the SEC has produced different rules in the past through the establishment of Ripple. Despite the fact that the United States of America is not as far along as other nations in terms of the popular adoption of the advantages of digital currency, this is undoubtedly the case. Not only does this provide assistance to extended banks and other financial institutions, but it also originates primarily from the Federal Reserve of the United States, which promotes the utilization of XRP for both local and international transactions. At the same time that it is working with Ripple to build its digital currency for central banks, it is essential that the United States Congress has accepted the global trend that nations such as China, India, Brazil, and others are going toward. It is the goal of the United States to continue to be ahead of the curve. That's all for now.